Welcome, and thank you for joining us for our business hour today. Today's topic is EEOC activism in 2015, Insights for Employer Compliance. I'm Miriam Rosen. I'm the chair of the Labor and Employment Group here at McDonald Hopkins. I'm based in our Detroit office. With me on the panel today are my two colleagues, Sarah Jodka from our Columbus office and Nicole Gray, who's here in our Cleveland office. We're happy to answer any questions you have from the audience. You have some cards, and if you fill them out with a question, members of our staff will be happy to pick them up. Those of you who are on the webcast can click on the email link on your screen. If you have submitted questions in advance of the program today, we'll plan to cover those questions during our discussion. If you're welcome to join the conversation on our Twitter feed by using hashtag MHBusinessHour. We're going to jump into our program now. If you're interested in EEOC issues, and if you are, that's why you're here today, you know that in the last several years, the EEOC has become more focused, more aggressive, and much more willing to push the envelope with novel issues. Now, in the past, the EEOC had kind of waited for issues to come to it. Not that they didn't handle those issues aggressively when they showed up, but they weren't looking for issues. Well, that all changed in 2012 when the EEOC issued its strategic enforcement plan. It set out really almost a task list of topics that it was interested in. It set 6 national priorities, and I'll give the EEOC credit, they've stayed on task. How have they done that? They have investigated matters more thoroughly and more aggressively. They have issued guidance on a number of topics, and we'll talk about some of those today. They have initiated lawsuits, again, some of those pushing the envelope, and they've even taken up some more modern methods by tweeting, and just recently, last week, they announced that they had implemented a trial system for online complaints. So you see, the EEOC is really focused on bringing people in and addressing equal employment opportunity. Now, today we're going to talk about 4 of the issues that we think are the EEOC's highest priorities, where we've seen the most activity. And when we say most activity, we mean we've seen guidance from the EEOC on these topics. We've seen aggressive litigation on these topics. And interestingly, we've also seen some court decisions, which makes it interesting because we kind of see how the courts are taking the EEOC's aggressive position and what they're doing with it. And the topics that we'll cover today are pregnancy accommodations, ADA and reasonable accommodations, background check issues, and sexual orientation and gender discrimination. Our goal today is to help you understand what the EEOC's position is, how they enforce the laws on these topics, and how you can stay EEO compliant. And with that, I'll turn it over to Sarah to talk about pregnancy discrimination.
Great. Do you have the clicker? Yep. The slides a little bit. Yep. Let's see. Okay, so we went over this one, and we went over this one. So this is where I'm going to start. We wanted to start today by talking about pregnancy discrimination, and one reason we really wanted to start with pregnancy discrimination is because we just got a huge decision from the Supreme Court with respect to pregnancy discrimination. One thing that was really interesting about the decision is that it came very soon after the EEOC issued some very controversial guidance on pregnancy discrimination. But this shouldn't have been anything that we saw that we didn't see coming, because we certainly had advance notice that the EEOC was going to start targeting this particular issue. In 2012, the EEOC commissioner tweeted, "Yes, we are serious about this. Pregnancy discrimination target of EEOC." And since then, they've done a lot with pregnancy discrimination. This has been one of the areas where we have seen them file numerous class action lawsuits and really target systemic violations in companies. And then, as I mentioned, they issued the 2014 pregnancy guidelines. Now, one thing we have to remember about the guidelines is that these are not binding. This isn't a court decision or anything like that. It's really just the EEOC's position on what they feel should be employers' approaches to pregnancy. And we're going to want to keep that in mind, because while the courts adopt what the courts adopt, in certain instances you are going to be dealing with the EEOC, so it is important to keep in mind what their guidelines actually say. What was interesting about the timing of the guidelines was that they came right after the circuit court came down on the Young versus UPS case. And many say that the timing was basically because they knew that this case, no matter how UPS versus Young versus UPS got decided, it was a case that was going to go to the Supreme Court based on the issues that were involved, which we are going to go over a little bit. The EEOC, many think that the timing of it was so the EEOC could get before the Supreme Court and basically say, this is the position we are going to take on this. They did file amicus briefs in the case. So what was so controversial about those pregnancy discrimination guidelines? Well, issued in July 14th, 2014, they were controversial in many respects. And the first was that they basically said that an employer was going to have to provide light duty to pregnant employees, even employees who were just having normal pregnancy. So pregnancies where there weren't any disability-related issues, normal pregnancy, there would be a requirement that employers would have to provide an accommodation for these employees. This is something we'd never seen before. No court had kind of taken this approach. The EEOC had not taken this kind of extreme approach. So many employers were really left scratching their heads. The reason they came down on this issue was this is the exact issue that was before the Supreme Court that was coming up for certification in the Supreme Court's Young versus UPS case. Some of the other controversial policies that came out of this was that certain employer inquiries, comments, or discussions regarding an employee's pregnancy or potential pregnancy would be indicative of discrimination. That was also something we hadn't seen. While sometimes those types of comments could indicate that there was pretext for discrimination based on other types of circumstances in the particular case, they basically said they would be, that these types of comments would be indicative of discrimination. So that was another broad approach that we had not seen before that was controversial in these guidelines. They also said that an employer health insurance plan would have to cover prescription contraceptives on the same basis as prescription medications that prevent medical conditions other than pregnancy. This was also very weird. This was also very interesting in light of the Hobby Lobby case that we saw just a few weeks earlier handed down by the Supreme Court at the end of their term in January 2014. So let's go back one slide. So what has happened since those guidelines? Obviously they were very, very controversial, and the Supreme Court in the last couple months did issue the decision in the case. Well, what have they done? Well, they've had to step back a little bit in light of the Supreme Court's decision, and that's what we're really going to focus on. We're going to really focus on what the Supreme Court's decision did to those guidelines and where we stand now. And they did say, okay, hold on. We realize that our guidelines we still like our guidelines, but we are going to take a step back from our guidelines and we're going to revise our guidelines so that now they fit within what the Supreme Court said we need to do in the UPS case. So that's good. And we haven't got those yet. We'll be waiting on those. And as soon as we get what those revised guidelines are, we will make sure that we provide them to everybody through our Business Advocate blog. So what's the bottom line? Well, they are going to interpret existing law to require accommodations to pregnant employees who are not disabled under the ADA. The Supreme Court's decision is in line with this, and we'll go over exactly what that means so you have some more clarification on it. They're also going to require accommodations for non-pregnant employees for lactation needs. So employees who are no longer pregnant but still have lactation needs. Now, we saw some new breastfeeding modifications, lactation accommodations, when the ACA came into effect for employers with employees who had more than 50 employees. So we saw these lactation kind of accommodation requests already being started to take into consideration by the federal government. The EEOC has also taken those lactation needs into account for non-pregnant employees who need to express milk. And according to the EEOC, an employer that offers light-duty work to employees with work restrictions must offer light-duty work to a pregnant employee with similar work restrictions. So let's take a look at the Young case, because this is kind of the fundamental basis of where the pregnancy accommodations, the guidelines are going to be going. Even though they haven't been revised yet, this is kind of where they're going to go, we assume, based on what the EEOC has said. So here's kind of the facts of the Young case. What happened was there was an employee, and she was having a normal pregnancy. She didn't have any pregnancy-related disabilities. So she didn't have preeclampsia, she wasn't put on bed rest, There was nothing like that. This was a normal pregnancy, but her doctor did put her on a lifting restriction. She worked for UPS, and she was supposed to lift up to 70 pounds. Well, this is a pregnant woman, and she's like, I can't lift 70 pounds. It'd be great if I could, but I can't. Well, the employer said, well, we're sorry. We're going to have to put you on leave because you can't do the essential function of your job, which is to lift 70 pounds. The problem with this is that the employer allowed non-pregnant employees light duty accommodation. So it would allow other employees not to have to lift as much in 3 circumstances. Those circumstances are if an employee was injured on the job. So we're talking about workers' compensation. If you had a workers' compensation injury, you could be given light duty. Employees who lost their DOT certification, so the employees who couldn't drive, they would give them this type of light duty. They would accommodate them. The last was if an employee was considered disabled under the ADA. Well, this case presents kind of a gap where there is somebody who may need an accommodation, but for all intents and purposes is not actually technically disabled under the ADA. They don't have a condition because pregnancy is not a disability under the ADA, and it doesn't look like it's going to be. This kind of bridges that gap. So they refused to give her light duty, and they put her on leave instead, and she sued. Now at the circuit court level, they said, look, the policy is pregnancy neutral. This is a neutral policy. So they said what UPS did was fine with us because they didn't do anything because of pregnancy. They didn't discriminate against her because of pregnancy, but the impact of it was. And that's kind of what the Supreme Court said. So the Supreme Court took this opportunity to kind of fill that gap and kind of turned pregnancy law a little bit on its head, something we haven't seen before.
Sarah, one of the things that is interesting, and I think from the district court perspective as well, is that many employers have the same policy in place. I would wager that a lot of you in the audience today and on the webcast have this type of practice, internal practice or policy of offering light duty to workers' comp, people with workers' comp injuries, and maybe not for individuals who are pregnant.
Exactly, and I think that that's why this decision and the guidelines that we're going to be getting probably in the next few months regarding pregnancy discrimination is going to be very important for employers. We are seeing so many more females entering in the workforce, especially of childbearing ages. And this is going to have to be something that employers do take a really, really hard look at. So when an employee comes to you and they are pregnant and it may not be a disabling condition, employers are really going to have to go back to their policies, go back to what they are doing for other employees who are not pregnant but who may need accommodations and accommodate them the same way. So let's take a look at exactly what the Supreme Court said so that we have better guidance of what we need to be doing with those pregnant employees. Essentially, the Supreme Court said that an employer may violate, so they don't say they will violate, they said you may violate the Pregnancy Discrimination Act, which was an amendment to Title VII, if it fails to offer an accommodation to a pregnant employee with a light duty restriction while providing the same accommodation to non-pregnant employees with temporary impairments. How broad does that reach? Well, I think that reads pretty broadly because if you have workers' compensation, you are pretty much almost always offering an employee light duty if they have an accommodation. If you have an employee who has ever needed an accommodation under the ADA, you are offering light duty for an employee who has a disabling condition who needs light duty. So while it says some of the commentators have been like, this won't affect every single business, I think it kind of will, because every employer who's going to be covered by the ADA will. Every employer who has workers' compensation will. And in Ohio, any employer with over 4 employees will, because you're going to be covered by our state law regarding disability discrimination, and that covers every employer with 4 or more employees. So this type of accommodation requirement essentially is going to touch almost every business as soon as there is a pregnancy in the workplace. Now, they did reject the notion that employers absolutely have to provide light duty. They were very clear. They said, we are not mandating that you do this. But like I said, when you really read the opinion and you really think conceptually and fundamentally about what this means to your workplaces and how it layers with other laws like the BWC with the ADA, that is kind of exactly what it means. It does mean you're going to have to provide this type of accommodation. It did say that it wasn't granting pregnant employees this most favored nation status, where they have kind of a heightened type of favoritism in the workplace because they are pregnant. But it is kind of, a little bit, because they are saying if you are a pregnant employee and your doctor gives you light duty, if the employer offers light duty for other employees, it should offer you an accommodation. To the extent it doesn't offer you accommodation, we will have to determine whether there is pregnancy discrimination. And it did issue something that was very different, and you don't have to really think about it too much right now, but it kind of also changed the way we prove cases. So this is going to change how basically our jobs in defending companies against pregnancy-related claims, because it changed kind of the prima facie burden. And we won't get into much of that today at all, because that's really not what this is about. Today is really just about where you guys really need to look with your policies as you go back in your workplace and as you start thinking about accommodating pregnant employees, because there is a new standard. This was a game changer, and we need to make sure that we know that. They did criticize the EEOC's broad interpretation of the ADA, of the PDA, which is, I think, one reason the EEOC is kind of going back to the drawing board with respect to the guidelines and redoing them in conformity with the Supreme Court. Because they said that the statute doesn't grant employees an unconditional most favored nation status. So here are the employer takeaways. Employers, you're going to be at great risk if you are not providing accommodations to pregnant employees. When you are evaluating a pregnancy accommodation request, employers should assess who are the comparators of the pregnant employees. Those are going to be your employees on short-term disability leave, long-term disability, ADA leave, workers' compensation leave. Those are what you're going to need to look at. Those are your comparators, your universe of comparators. What you're doing for them, they're going to be in the same class as pregnant employees. It's no longer, well, what did we do for Jane 9 months ago, who was another pregnant employee? What did we do for Susie, 2 years ago when she was pregnant? The field of comparators has changed. We will no longer be looking at what the employer did for just pregnant employees 3 years ago. We will be looking at what they did for every person who needed a light duty accommodation for the past years in the same type of job. That's what we're going to look at. It changed the universe of comparators, essentially. And since the amended ADA broadened the definition of disability, many pregnancy-related impairments also fall within the realm of the ADA, meaning even if it's not covered by the PDA. So if this isn't a normal pregnancy, you still may be looking at what you've had to do with respect to accommodation under the ADA, to the extent there is someone to be on bed rest, who has preeclampsia, who has high blood pressure, who has other pregnancy-related conditions that would amp this up into the covered by the ADA. So we're going to have a Title VII for a normal pregnancy, but to the extent that there is an actual disability, we're still going to have to go by the ADA requirements. So we've got two statutes that could be impacted by this.
Let me jump in here for 1 second before Nicole starts. So again, I kind of want to bring in some of the ways that the EEOC is being activist and getting its message across. So I happened to find this. Our favorite EEOC commissioner, Kai Feldblum, who tweeted just on Monday, "No, you can't fire an employee on her first day 3 hours after you find out she's pregnant." The EEOC is hot on the pregnancy issue. You see it from their guidance. You see it from the many cases they're filing. If you follow Commissioner Feldblum, you will know that she frequently tweets about pregnancy discrimination cases. So it's something that you have to be aware of. It's a new normal, as Sarah said.
Right, and as the EEOC is pushing the envelope with respect to pregnancy and not going so far as to say a kind of run-of-the-mill pregnancy is going to be covered by the ADA, certainly the conditions that may come from a pregnancy would fall into a coverage of under the ADA and potential disability. So moving to talk about some of the EEOC's other interests, among that being the Americans with Disabilities Act. And as we have here on the slide, it's been 25 years since the ADA first went into effect. So
I bet some of you feel like it's been longer.
Yeah, especially recently. I think there's been so much change, I would say, over the past 5-10 years with how employers face ADA situations and the burden that is now on employers that was not there, or certainly not there in at the level that we're seeing now. Just to set the stage so that everyone's on the same page, the Americans with Disabilities Act makes it illegal to discriminate against a qualified person with a disability. The ADA also requires an employer to reasonably accommodate the known physical or mental limitations of an otherwise qualified individual with a disability who is an applicant or an employee, unless doing so would pose an undue hardship on the operation of the employer's business. And as many of you, I can see a few faces out there in the audience who we've talked about this situation, showing an undue burden is a very high hurdle for an employer. The EEOC has certainly taken an active interest in the ADA and has really taken aim at employer policies and practices that restrict employee rights under the ADA. We've talked previously in prior roundtables about inflexible leave policies or no-fault attendance policies that are big targets of the EEOC. And we continue to see charges that, EEOC charges that address those issues, and the EEOC during investigations of charges that may even be unrelated are asking for attendance policies and asking for leave policies to ferret out those types of violations. But also, the EEOC is challenging employers on reasonable accommodation issues. And when we're talking about reasonable accommodation under the ADA, it essentially means that an employer must modify a job or the job environment to enable, again, a qualified individual with a disability to perform the essential functions of his or her job. The EEOC is really looking past the analysis of whether an individual has a disability to how do we accommodate, and really going to that next step. They're sort of glossing over that initial analysis of whether or not this person actually has a medical condition that would qualify as a disability. And that's due in part to the expansive definition that we got of disability back in 2009. But some key points to remember with the ADA, and then as we're talking about reasonable accommodation, is that unlike the Family Medical Leave Act, there's no length of service requirement with the Americans with Disabilities Act. So you have an obligation at the applicant stage to consider these issues, as well as the first day that that person becomes an employee. Also, unlike the Family Medical Leave Act, the ADA does not set a limit on the length of a leave, for example, that may be a reasonable accommodation. So an area where I see employers struggling is we usually say, we sit up here and tell you, be consistent, treat everyone the same. And the ADA is an area where actually doing that can cause an employer to have issues, certainly with the EEOC. The EEOC has taken the position that each disability case is an individual case, and you need to assess based on those specific facts and circumstances. And that reasonable accommodation at the end of the day really does mean preferential treatment for that individual if they have a medical need that requires an accommodation. There may be a range of possible accommodations that might assist the employee. However, the employer is only required to provide an effective accommodation, not necessarily the one that is requested. So when we're talking about reasonable accommodations, some things that come to mind are the modifying the job, the actual physical location, the employee's desk, their computer screen, for example, modifying a work schedule, flexible leave schedules, changes in technology. And this is an area where the EEOC has taken an aggressive stance, and specifically on telecommuting. So the idea of being able to work from home. And this has been not only the subject of the EEO focus, but also came under scrutiny in a recent case of EEOC versus Ford. Here, and we put up the facts, I'll just briefly talk about this case, but you have Julie Harris, who was a purchasing employee, who requested to work from home up to 4 days per week on an as-needed basis. She had irritable bowel syndrome, and it was unknown to her when it may flare up, so that she would not be able to be in the workplace and would rather be able to work from home. The company denied the request because regular and predictable attendance at work was an essential function of the job. I see some of you shaking your heads in the audience. Yes, that makes sense. You should come to work. The employee was later terminated for her inability to come to work. The employee filed an EEOC charge, and the EEOC sued on her behalf for disability discrimination and retaliation. we have the district court that dismissed the case, finding the employee was clearly unqualified for her position because basic attendance was a requirement of most jobs. Then it goes to the Sixth Circuit, and we have a 3-panel decision that comes out that acknowledges that technology has expanded the workplace, and the Sixth Circuit held that a reasonable accommodation may include telecommuting. So then the decision, Ford asked for a full panel to review the case, and the full Sixth Circuit ruled in April that the employee was not qualified within the meaning of the ADA because she could not regularly attend work. The employer had established an on-site work as an essential function through their job description, their policies, their practices. They were able to show that other individuals who occupied that position had to be at work, and were able to establish that the need for interpersonal communication and interaction was necessary. The court did give us this language that I think is going to appear in many briefs, is that with few exceptions, an employee who does not come to work cannot perform any of his job functions, essential or otherwise. Essentially what the Sixth Circuit did was combine legal analysis and kind of common sense business considerations in finding that Ford was not required to provide an as-needed telecommuting situation as a reasonable accommodation, because at the end of the day, Harris was not qualified to perform the essential functions of her job, which, although the EEOC likes to gloss over that part, that is a prerequisite to whether or not you have a entitlement to a reasonable accommodation. You have to be a qualified individual with a disability first. Importantly, Ford was able to demonstrate that, again, the regular and the on-site attendance was an essential function of the job. They also could show that they had tried to work with Harris on a flexible work schedule, and she could not regularly and predictably appear for work. So they had engaged in, again, this interactive process to see if a reasonable accommodation could be fashioned. The court here, again, noted that most jobs require the kind of teamwork, personal interaction, and supervision that simply cannot be had in a home office situation. So the takeaways from EEOC versus Ford is, does that mean telecommuting is a no? We don't have to do it? Well, no. That's not what the takeaway from Ford is. And that's where I would caution employers when assessing these. It's quick. We're sometimes quick to dismiss things, dismiss accommodations, saying we could never do that. And our challenge or our obligation is to investigate, and through that interactive process, determine what is a reasonable accommodation and not say no out of the gate. So here, again, importantly, Ford did try to accommodate Harris with a limited telecommuting schedule. It didn't work. And the court made much of that they had engaged in that. Based on these particular facts, telecommuting was not a reasonable accommodation, but that certainly doesn't mean that it wouldn't be appropriate for another situation. And the court really left the door open for the use of technology in evaluating reasonable accommodations based on, again, the essential functions, the nature of the essential functions of the job. Another takeaway for employers is job descriptions, and I know if you've come to our past roundtables, this is sort of my point that I always harp on, is job descriptions. Your paperwork should really drive what is an essential function of the job. And the court noted that under the ADA, employers have the responsibility of establishing job functions. And it's the one place where the EEOC actually gives employers some deference as to what you've established as the essential functions of your job. So make sure it's in there. If teamwork, personal interaction if those are essential functions of the job, you need to have that in your job description. So an employer may understand the types of reasonable accommodations that may have to be made, but the question then becomes, how does it identify an effective one? And that's really where we need to use the interactive process. And another area where the EEOC has really taken aim is on employers and kind of where that breakdown in the interactive process occurs. Is it on the employee side? Did they not provide documentation as required? Is it on the employer's side? then investigate adequately. Generally, it's an employee's responsibility to communicate a need for an adjustment or a modification to a work environment due to a disability. However, you don't have to use magic language. I don't have to say, I am implementing the ADA and I need to have a reasonable accommodation. No, it's not going to come to you that way. It's probably going to come to your first line managers or supervisors, not to HR. So it can be as simple as, I'm having trouble getting to work at my scheduled start time because of medical treatments. I'm getting headaches from the glare on my computer screen. Those are sufficient to put an employer on notice of at least a discussion needs to be had about a reasonable accommodation. Now, these may not end up being disabilities, but at least it triggers that interactive process. Something like, I don't like my chair, I want a new one because it's uncomfortable, doesn't trigger a request, or it's not enough to put an employer on notice of a need for a reasonable accommodation. What we're looking for is a request for a change at work because of a medical condition.
Let me give you an example of one I had recently, and where employers sometimes might say, this is just an employee complaining. Coworkers were having what someone called a perfume party. They had ordered a whole lot of things from Bed Bath & Beyond and were trying them on at work. Coworker complained because she had a sensitivity to fragrances because of asthma and maybe some other conditions. I think the employee with the sensitivity had asked her coworkers, but they kind of poo-pooed it and thought she was just being difficult. And certainly there were probably some personality issues involved. But at some point the employee went to HR and made a complaint. And at that point, HR had to take it seriously. And what did they do? They followed a process that I'm sure Nicole is going to explain to you, got medical documentation, and found a way to address the situation. And in this case, without moving the employee's desk, which may have made her feel ostracized. They got a fan, they got something to purify the air, and they asked the coworkers not to do that in the person's work area. So Nicole's going to talk about that process, but I think that that's an example of something that they were all easy fixes, but something that an employer could have just said, we don't need to do that, just deal with it.
Right, exactly. And so when the employer has this notice, is now put on notice, that triggers the obligation to then engage in an interactive process. And again, some of these things may not turn out to be disabilities. Some may be a quick fix. An employee who complains about the glare on a screen, and when the employer says, well, is there anything that the company can provide you in order for you to do your job? And the employee says, yes, at Staples, they have a $25 screen I can put over my computer to block the glare. Great, quick fix. We document that we had this discussion, we document that we gave an accommodation, and we check in with the employee to make sure it's effective. And we can do that without medical documentation. However, sometimes the disability may be unknown, the condition may be unknown to us, we may need more assistance in understanding what the condition is it a disability, and then what may be an appropriate accommodation. There are some situations where, again, I said at the beginning that it's generally the employee's burden to put the employer on notice of a need for reasonable accommodation. The EEOC, however, has given some guidance as to situations where it may be appropriate for the employer to initiate that interactive process without being asked by the employee. And that's essentially when the employer knows that the employee has a disability, knows that the employee is experiencing a workplace problem because of the disability, and knows or has reason to know that the disability prevents the employee from requesting that reasonable accommodation. Sometimes this may come up in psychiatric conditions, such as a bipolar situation, where you observe an employee who is behaving in an erratic manner, and it may be indicative or suggest that he's experiencing a manic episode, for example. So that may be a situation where, again, it's limited situations where the employer may have to initiate that interactive process. Again, asking the employee, is there anything that you need in order to do your job? Is there anything that the company can provide in order for you to be able to perform the essential functions of your job? If they say no, document it. document the conversation, and move on. That doesn't mean that you won't reinitiate that at some point in the future, but at least for that time period, you've established that you've at least done your obligations as an employer. So again, part of the interactive process is determining what may be a reasonable accommodation. What is the medical condition as far as is it a disability, and then what may be a reasonable accommodation. The EEOC has given us guidance, again, as to when are these times when an employer can request medical information. Generally, an employer can seek information about an employee's medical condition when it's job-related and consistent with business necessity. However, when an employee is asking for a reasonable accommodation, the employer can obtain information about the medical condition. We need to be cautious, however, that it's not all-inclusive. We don't get to see every medical record that this employee has out there. We get to see what is relevant in order to determine what the condition is as far as is it a disability, and then what reasonable accommodation may be appropriate. So essentially, we're looking for sufficient documentation to be able to move forward in the interactive process. Documentation would be sufficient if it describes the nature, severity, and duration of the employee's impairment, the activity or activities that impairment limits, and the extent to which the impairment limits the employee's ability to perform activities. The second is that it would substantiate why the reasonable accommodation is needed and give the employer an understanding as to what reasonable accommodation would be effective in this situation. What is it that the employee needs? They have this medical condition, but what is it they need to be able to do their job? And part of this interactive process is going to be driven by the employer getting the information to a healthcare provider in order for them to understand what is it that this employee does. I mean, I can come and say that I run a drill press to my doctor, but if I don't have if the doctor doesn't have the detail about what that entails, that I'm on my feet, 8 hours a day, that I have to lift objects that are 10 to 50 pounds, that I have to, pull and push on a regular basis. If we don't have that information, they're not going to be able to give us the full, or the sufficient information we need to assess a reasonable accommodation.
And remember one other thing when you're getting that information, that the ADA process and finding what an appropriate accommodation is different than the FMLA process. So lots of times I see employers using FMLA forms to get information about accommodations. Well, the FMLA only cares about if you have a serious health condition, not how you accommodate it. So it really is a different inquiry. We all have standard forms that we use to get the information about how do you accommodate this condition, allow the employee to perform the functions of their job, as opposed to they have a serious health condition and can't do their job.
And a lot of times this will require, again, ADA issues are a marathon, not a sprint. And those of you who I talk to on a regular basis, I see you nodding your heads. That I say that a lot because it will put a burden on the employer to go back to a healthcare provider and say, this was great that you gave us a diagnosis, but we need information about what is a reasonable accommodation here, what's being limited, and how does that impact their ability to do the job. So just taking that first response from a healthcare provider may be insufficient.
I'm going to tell you another story. This morning as I was driving in, I was talking to a client about 2 medical certifications. They got both of them, said that employees couldn't do the functions of their job. One simply requested that an employee who has a job that requires physical activity should just have a desk job. That was the only accommodation it offered. Well, the employer doesn't have desk jobs for the employees who do physical work. And the other one was an employee who had surgery several months in January, but still needed between 3 to 6 months off. The employer wanted to know, where do we go from here? We've got the medical documentation, or do we make a decision? What do we do? And in both cases, we have to go back and get more information. We still need to understand for the first employee, are there things we can do so the employee can do their job, not a different job? And we need some more information. As it turned out in the second case, the employee had provided documentation from their internist as opposed to the surgeon. So we need some more specific information from the person who's actually treating the employee for the condition. So, again, I completely agree with Nicole. Absolutely a marathon.
And something that I'm seeing a lot more of, I know Miriam is as well, is psychiatric conditions and how those are playing out in the workplace and the need for accommodations as well. And this is certainly something that the EEOC has an increased focus on. And it's something that employers may be less familiar with an accommodation for an employee with a disability that's not visible. So bipolar, ADHD, generalized depression. Those things that are now, we're getting, healthcare providers giving us diagnosis, but nothing more. I mean, that's, an area where we need to make sure that we're going through the interactive process to understand what's the condition and then what's a reasonable accommodation. And here, mental health professionals, including rehabilitation counselors, may be able to help in this circumstance. It may be just beyond their treating physician who's able to give a understanding of what they need in the workplace. So, vocational experts who would be able to help an employer assess what is it that this individual needs. Do they need a job coach? Do they need a weekly meeting to stay on task, right, with their supervisor? Does it require a change in that supervision structure? So when we're talking about the interactive process, again, we said we wanted to get medical documentation. We need to be mindful that it's not overly broad, that our request for information is limited on being able to understand, does this person have a physical or mental impairment that substantially impairs their ability to perform an essential function of their job, right? So are we looking at, do they have a physical or mental impairment that is substantially limiting one or more major life activities? And if so, how does that relate to what their job activities are? For example, if they have a limitation on driving, yet they don't drive, is that something that the employer has to accommodate in the workplace? Maybe, maybe not. So we have to look at what is the condition and then what's the essential functions of the job. You want to be mindful when you're drafting requests or getting information from doctors of that you're maintaining confidentiality, that only individuals who have a need to know have that information, and that you're limiting that. It's not something that you're giving medical documentation to the supervisor, for example, while the supervisor may be essential in helping to develop a reasonable accommodation, understanding the job, what needs to be done, as well as making sure that that is implemented on the shop floor, for example. They don't need to have the medical information. And again, making sure that those requests are not, they're narrowly tailored.
One thing I'm seeing a lot of is issues of how do you, coworkers are seeing more accommodations made for other employees. And they're curious, why does so-and-so get this preferential treatment and I don't? Where is so-and-so? They're on a leave of absence. And it's sometimes hard for supervisors to know how to respond. So you, as HR, you have to know how to coach the supervisors in that. I happen to have a charge of discrimination right now where one of the allegations relates to a communication about an employee who was on a leave of absence. Now in this case, the employer's communication was appropriate. All they said was the employee was on a leave. They didn't disclose anything. But people started texting and messaging the employee, which is different than how it used to be. And the employee all of a sudden thought everyone knew the details of his condition. That wasn't the case, but what's happened now? The employer has to address it. So it's very important, especially when communications are so easy now, to make sure that we're kind of tight-lipped about those issues.
And that actually feeds right into tips for the successful interactive process. And number one tip is to train your managers and supervisors to be cognizant of employee requests that may trigger the ADA, because odds are they're the ones who are dealing with are being put on notice and hearing the concern raised by the employee about their medical condition and causing a need to have something changed or modified in the workplace. You want to make sure that you're engaging, that human resources is engaged at an early point in the process so that they can manage and document this interactive process, and make sure that medical information is remaining confidential. And again, I think we need to make sure, and the EEOC is telling us that we, as employers, need to make sure that we are engaging in the interactive process and we're doing it fully. that we're not shutting down employee requests out of hand, that we're actually showing that we're taking this seriously, we're investing the time and resources to be able to evaluate an employee's ability to work and perform the essential functions of the job. Again, I take you back to the EEOC versus Ford, where the court specifically pointed out Ford's attempts to work with the individual and prior to termination. So we go back to, can't say it enough, good documentation. Make sure that your job descriptions are up to date and they're accurate as far as what are the essential functions of the job.
Well, Nicole, I happen to have a question right here about that. Someone emailed us a question, would like to know, should regular attendance be added to job descriptions?
Again, I don't think that it hurts to say regular attendance is a necessary or essential function of the job. Again, though, just putting it on your job description, if it's a situation where you can perform that job from a remote work site, you can still attend work. So certainly, as the court has told us, attendance, showing up and performing your job is an essential function, but where you do it may be job dependent.
But if being on-site is
Yes.
required, it's a good idea to say
Right.
regular on-site attendance. And then to be cognizant of your practices, because if you say it, but you're really letting people work from home, and decide when they can work from home, that could come back to bite you.
And one thing that I found so interesting about the Ford decision, I was so happy that they took it up en banc, was whenever the Sixth Circuit first reviewed this decision and they came back and said, we're going to, reverse summary judgment, we think that the employer made the wrong call here. One thing, and if you've read, your attorney's briefs whenever we brief these issues, is every time we say a court will not sit, we cite the case, a court will not sit as a super personnel department and make decisions that HR needs to be making. That first decision said, yes, we are. We are exactly going to sit as a super personnel department to the extent we feel we need to, and we will change your policies. Well, thankfully, I about had a heart attack when I read the first decision, because I was like, this is going to gut pretty much a lot of the arguments that I typically would make in these type of instances. So on en banc, they got rid of that language, which still allows now employers the autonomy to kind of make those personnel decisions that it needs to make with respect to these accommodation issues. Do we have another question?
We do have another question. This is a tricky one. I've had this question come up. So what if an employee is prone to having seizures? Would you have to tell the supervisor the medical condition? And this could be seizures, it could be any medical condition where the employee may need treatment throughout the day.
So again, I don't think that there's a requirement to give the supervisor a medical diagnosis or medical information. Again, if there's a condition that's going to cause something in the workplace and an accommodation is needed because of that, the discussion is around the accommodation rather than the physical or mental condition.
And I think the point is, it's not that you can never tell the supervisor, but you have to have a business reason for disclosing it to the supervisor. And certainly when you're disclosing something to the supervisor, you want to train them so they know not to share it.
Well, as we've seen, these accommodation issues are, we've dealt with pregnancy, we've dealt with accommodation, huge issues that the EEOC has been taking on. The next issue we want to bring your attention to is another huge issue that the EEOC has basically taken up a charge with, and that's with respect to background checks. Why would the EEOC care about background checks? Well, in its 2012 Strategic Enforcement Plan, it said it was taking on impediments to hiring. Well, background checks are something you do prior to hiring. And so they started taking a look at background checks and how background checks are being used to discriminate against certain employees. Well, how does that play in? Well, it plays in with the EEOC under Title VII, which it enforces. Title VII prohibits discrimination in terms and conditions of employment based on someone's ethnicity, their race. So where this comes in is, let's think about it, credit checks, criminal background checks. The EEOC looked at statistics that demonstrated that employees who were of minority status were more likely to have lower credit ratings, they were also more likely to be incarcerated at a higher level than the regular population, and that these use of credit checks, the use of criminal background checks, was having a disparate impact in some workplaces on minority employees. So the EEOC in 2012 issued another set of guidelines that we talked about before. They like their guidelines that addressed criminal and credit checks because of the disparate impact that they saw. Now, there's a difference between disparate treatment, where you are treating one employee differently than another employee with respect to background checks. Basically, you're background screening one employee and screening them out, but not everybody else. What the EEOC is really, really targeting and really cares about are the systemic violations. And we know that because of the types of lawsuits that they've filed. They aren't filing individual lawsuits based on one person's background check. They're filing it if they see that there is a neutral policy that the employer has, like a blanket policy that says, we will not hire felons. If you have a felony conviction and you disclose it, we will not hire you. The EEOC, pretty much every case that the EEOC has taken up, that has been the blanket policy that they claim is being used to negatively, disparately have an impact on minority employees. So those are the cases we're seeing. So we're not seeing those kind of one-off cases. We're seeing the systemic violations. They're filing huge class suits, not individual one-person background checks. So let's take a look at credit checks. The EEOC's position on credit checks is that, of course, they can lead to disparate impact. And for the reasons we said, some minorities have a greater impact of having a lower credit score. So to the extent you're looking at someone's financial background, you may negatively impact a minority employee. So basically they said, look, this can lead to discriminatory hiring practices, and I don't disagree with them. And they said, and unless you're going to, you can use credit checks. We're not saying don't use credit checks, but only use credit checks in certain instances. You don't need to be credit checking every single employee who walks through your door. There's really no need, especially people who have no access to money, who finance has nothing to do with their job. This is maybe a blue-collar worker who's going to be working on a manufacturing site or production facility. Why do you need to know their credit score? Because you don't. And that's what the EEOC is saying. They're saying, employers, let's just use a common sense approach and let's think about this. If there's not a business need for this information, let's not use it to keep someone out of employment.
I have to tell you, what I've been seeing is actually employers kind of pulling back. I don't know if it's because of the EEOC or just because of, frankly, the cost, and that they've discovered themselves over time that there's no correlation.
Exactly. So the best practices for credit checks are be selective. If this isn't somebody who's going to be CFO or have, you're not a bank, this person doesn't even have access to money, you don't need to look at their credit history. Have a legitimate business need as to why a credit check is going to be needed. Ensure that managers are only using information that's actually relevant to the job in question, and allow the candidate to explain if there's a blip on their credit history. And that actually plays in really well with employers who actually already have to comply with the Fair Credit Reporting Act. The EEOC, the guidelines were really, employers really took a step back on this and had a really negative reaction. But essentially what the EEOC was saying is just follow the Fair Credit Reporting Act on these things. So you could comply with what the EEOC says and what you had to do with the Fair Credit Reporting Act anyway. But they had a real negative reaction. Yes, you have a question?
Define minority.
Minority. The question was define minority. What the EEOC said with respect to the statistics were that African American employees and Hispanic employees were the ones being most negatively impacted by the use of background checks and credit checks in the workplace. Those were the statistics that they primarily focused on in these guidelines.
And actually female applicants as well for credit checks.
So when it comes to criminal background checks, here's what they essentially said, okay? They said, if you're going to, we don't want to see any blanket policy. So if you have a policy that says we do not hire felons, we will be very unhappy with you. And if we see it in your application, we will come after you seeing that there might be a violation. They said we won't say that there is a violation, but we're definitely going to come after you and really look at it. And we may file a suit against you, which some employers have had. So what they basically said is you need to have a targeted screening process. So instead of just blanketly throwing out anybody who had a felony conviction, you need to take a targeted look at this. And here's what they said. A targeted screen means that you have to consider the actual requirements of the job. Is this in line with business necessity, what we're actually looking at, to determine whether there is a business justification that exists to deny the employment based on the criminal background check. And they said, we want you to do an individualized assessment. And this is the part that sent most employers running from it, because they said, we can't do an individualized assessment for every single person that we hire. Well, you don't have to do one for every single person you hire, just the ones that come up with a criminal conviction. And here's why. Say you have an employee who has a DUI, and it's considered a felony where it was. Say it was a third strike or whatever. Well, this person has a felony for a DUI. Guess what? They don't drive a company car. Why do you care? Because you shouldn't care, because it's completely unrelated to what they're doing. And that's what the EEOC is basically saying. You need to look at the actual felony. You also need to look at the nature and gravity of the crime. Are we going to keep someone from having a production job because they have a DUI? No, as long as they can get to work, who cares about whether they can drive a car or not? It really doesn't matter. You need to look at other things. Is this person, who has a crime of a white-collar crime, but they're not doing a white-collar crime? So actually look at what they're going to be doing for you and what the actual felony was. The nature of the job, if it falls in line, it's the same thing. The age of the crime. Felonies always pop up on a criminal background check. And here's why. The Fair Credit Reporting Act allows for the reporting of felonies no matter when they were. Okay, but if you had a bankruptcy, it's only going to show up for 7 years on a background check. Because under the Fair Credit Reporting Act, that's the only time period it's allowed to come up. It can only come up for 7 years. So if someone had a bankruptcy 15 years ago, you're not going to know about it because it's not going to pop up. If someone had a felony, it's going to continue to pop up. 20 years, 50 years, whatever. Felonies continue to pop up. Other things are age restricted out and will not show up after a certain period of time under a normal background check. So, but if you're 18 and there's like a petty crime, a petty theft, do you want to be screened out when you're now 36 years old, 20-some years later, because of a petty theft, something you did at 18, but it's still showing up in your background? The EEOC says, we need to take a look at this. This may be just an 18-year-old who did something stupid because that's what 18-year-olds do, as opposed to somebody who had a clean history from then on and did nothing else. We need to look at those things. And other extenuating circumstances, essentially giving them time to basically come back and explain what they did. Basically say, yeah, I got caught up into something when I was 18 years old. And what I think is important about this is that you've got to do that under the Fair Credit Reporting Act anyway. That's why I say this, it's not hard to comply with Title VII and the Fair Credit Reporting Act, because if you are conducting a background check anyway, you have to give the person written notice that something popped up in their background, and you may exclude them from employment from it. And you have to give them a reasonable amount of time to explain that why they shouldn't have an adverse action taken against them because of it. That's exactly what the EEOC says you already have to do. Yes, another question?
Our application, it specifically asks, have you ever been convicted of a crime? A lot of people couldn't know because 30 years ago it was going to be on the record, but we get information back that it's still on their record. So how would we say you lied on your application?
And
Can you repeat the question?
Yeah, the question was, we have an application, and the application says, have you ever been convicted of a felony? And a lot of people say no, and they don't explain the situation. And her question was, what can we do about that? Because we've been terminating them for lying on their application. And I say, yeah, terminate them for lying on their application. You ask a question. You're allowed to ask the question. And so long as you're allowed to ask that question and they aren't truthful for it, that is a reason to take an adverse action because you gave them time to explain it. Now, one thing I do want to caution you on are the laws that say you're not allowed to ask the question. There are a lot of laws that say you're not allowed to ask the question. If you are a nationwide employer, you are an employer who employs outside the state of Ohio, be very, very careful and consult with your counsel and have that application reviewed because there are what's called ban-the-box laws in certain states and in certain jurisdictions. And we keep seeing new ones that basically say you can't ask the question. You can't have the question on your application at all. So if you're an employer outside the state of Ohio, because Ohio does not have a state ban-the-box, now it does have it in some municipalities, Canton, Cincinnati, Cleveland. Some different municipalities, if you're seeking municipal employment or locality employment, have ban-the-box restrictions. But I would always just say, if you have an application that questions on there, make sure you're working with your counsel to the extent you're not a public employer, you're private, and you're outside the state of Ohio to make sure you're in compliance with those ban-the-box laws.
But if our employees say no because they say, well, it's expunged, so they don't think it's going to come up on their record, but it does. So does expunge mean that it's not going to be on their record?
The question there was, what if they didn't report it because they felt that it was expunged? Well, there is the state Ohio law says that we're not allowed to ask about expunged records. So I would hope that your application says, do not report sealed expunged records, because there is a specific Ohio law that says we're not allowed to use expunged information. Now, to the extent that something pops up that was supposed to be expunged, or they thought it would be expunged, I think you need to look at whether it was expunged, whether they really expunged the record, and you're going to have that conversation, because you're going to have to figure out if they really lied about this, or this was an expungement that was meant to happen and didn't. It's going to require a little bit more work on your part, unfortunately, but you are going to have to take into consideration that in Ohio we're not allowed to look at expunged records. They don't count. We just have that specific law. You're going to have to take a little bit more look into it, and make sure your application does say, do not report anything that was expunged or sealed, because we're not allowed to look at those anyway.
But the burden's on them to provide you, with information about that, because that a lot of people have that as their response is, oh, I thought that was expunged, and they haven't really taken the actions or the steps to do anything to expunge it.
Now, here's just a few cases, and I'm not going to go over them because the EEOC has not been faring very well in their takedown of background checks for various reasons, none of which have anything really to do with background checks themselves. It's just been their inability to prove that there was actually a disparate impact. And these are some of the cases. So best practices, really, what are your takeaways? My best takeaway I can tell you is comply with the Fair Credit Reporting Act. Whenever you're doing the Fair Credit Reporting Act compliance, you basically do an individualized assessment after that pre-adverse notice with the employee. Now, the guidelines never told employers when to actually do the individualized process. So I had a lot of my clients coming to me going, I don't know how to comply with it. The EEOC gave us all these guidelines and never gave us a timeline of when to do it. I say, well, that's great, because I actually know how the FCRA works pretty well. So let's just tie it into our Fair Credit Reporting Act process that we already have to do, and we will wrap this thing up with one pretty little bow and make it an easy process for you. So that's what employers that I've been working with have been doing. We've been doing the individualized assessment after the pre-adverse notice letter goes out. We give them time to respond, whatever time we feel is reasonable. If they do not respond, or when they do respond, we do the assessment about what the background, what the crime was, what the job is, how long ago. We do that. Then if it comes up that we're still going to exclude them from employment, then we send the adverse notice letter, which we have to comply with under the Fair Credit Reporting Act anyway, and our job is done. Now, we may come to the decision that we're not going to exclude them from employment. Maybe this is somebody who has a felony DUI, but they're not going to be driving a car. Great, thank you for explaining. You're hired. We don't have to send you the adverse notice letter because you're going to come work for us. And that's kind of the way we've been approaching it. We've been complying with both laws at the same time to make the EEOC happy and the FTC happy at the same time. So, and that's kind of where it goes in with the best practices. Just apply with these same things. Make sure that it's job related and it's consistent with business necessity. Employ the targeted screening process, which is just kind of weighing those factors. And here are the factors that we suggest that you weigh. And it's not just my suggestion. These are the factors that the EEOC is saying, please go ahead and weigh.
Okay, now some of you might be thinking, wait a second, I understand Title VII. Title VII doesn't protect sexual orientation. It doesn't protect transgender status. So how can the EEOC be interested in these areas? Well, let's take a look at how that happened. The EEOC made LGBT condition status one of their priorities with the strategic enforcement plan, and they've taken a number of steps since then to really aggressively pursue that. Frankly, before 2011, the EEOC rejected charges of discrimination based on sexual orientation, gender identity, transgender status. We have seen in really 4 years a huge shift, and let's face it, it reflects the shift that we're seeing in the country. So as I said, they made LGBT status a priority in the strategic enforcement plan, they issued a memo in 2012 to their investigators saying, accept these charges. Now, some people say, wait a second, how's it all covered? Because Title VII is pretty specific about what's a protected category. Well, the EEOC has a theory, and as we'll see, it's a theory that's proving to be pretty effective. They've said that these categories fall within sex discrimination, that people decisions are being made on gender identity based on how you're viewed in terms of your sex and sex stereotyping. In 2013, the EEOC began tracking LGBT complaints, and then, this is how we really know that the EEOC is serious. Just in September of 2014, they filed 2 lawsuits based on transgender status. And frankly, as we're kind of looking at this, the EEOC seems to have been most aggressive related to transgender status, and I can't quite explain that. I don't know if those are just the cases that have come up, or for some reason they feel that it's a better argument. One thing that we're seeing is that it's not just the EEOC, it's other government agencies too. So if you're a federal government contractor, you know that there's an executive order last summer that now protects LGBT status for federal government contractors. And then in December, Attorney General Eric Holder said that the Justice Department would consider LGBT status protected under Title VII. So 2012, we saw the first case related to transgender status. An ATF agent applied for a job as a male and basically believed that he was going to get the job and then notified ATF that he was transitioning to a woman. Surprisingly, ATF told the applicant that the job was no longer available. Where'd the ATF make a big mistake? Well, they actually went out and hired somebody else. The applicant filed a charge of discrimination, so this was a federal employee. It went through the EEOC federal system. And this is when the EEOC came back, and we really looked to this as the first decision, came back and said actions based on transgender status are actions based on sex and therefore covered by Title VII. And we've kind of been off to the races since then. So I mentioned the 2 lawsuits that we saw in September of 2014. One was in Lakeland, Florida. The other one was actually at a funeral home in Michigan. And what's interesting is the theory of both cases is basically the same. Employees transitioning from male to female, no performance problems, but they're quickly terminated. And the EEOC's theory was they were terminated based on the employer's gender-based expectations, preferences, or stereotypes. Now, here's something that's really interesting. Just last month, we had activity on both of those cases, so you can see where this is going. And the case out of Florida was settled for $150,000. The employer agreed to be monitored by the EEOC for 2 years and to set up policies related to sexual harassment and sex discrimination. So, no one wants to be monitored by the EEOC for 2 years. We actually had a decision in the case out of Michigan. There, the federal district court judge said, the employer asked the court to dismiss the case. And the judge said, if you had just said this was based on transgender status, I would say, no, Title VII doesn't protect transgender status. But what the EEOC argued was this was sex discrimination based on, what we have here, gender-based expectations, preferences, and stereotypes. And so the court said, maybe it is sex discrimination. The court did not dismiss the case, which means, if any of you have been involved in litigation know, we're going to proceed through discovery, and we're going to potentially have a trial and find out what the court has to say, what a jury has to say about whether transgender status is protected. So that's going to be an interesting case to follow, potentially one of the first cases where we'll see a decision, likely an appeal. Again, I go back to the EEOC commissioner who likes to tweet. She's telling us again that EEOC is a friend to transgenders and they can turn to the EEOC for protection. And one more case that I want to bring to your attention. I think one of the most difficult things about, in particular, transgender employees in the workplace is how other employees feel. They may feel uncomfortable. What bathroom should the employee use? Where do they fit in? And so this was a case, again, just recent in the last couple of months, decided by the EEOC regarding a federal employee, transitioning employee from male to female. And there was initially an agreement that the employee would use a single bathroom as opposed to the general restroom. Something happened, the employee started using the general restroom, and chaos ensued. The employee filed a charge of discrimination. This was the EEOC's decision, and you know, I think that the EEOC got it right in this case. And they said that while it may be uncomfortable for other employees, it may cause some confusion, we can't make our decisions about equal rights based on other employees' feelings. I think if you apply that to any other protected category, we would all agree that's accurate. So there's no doubt that you can see in just from 2011 to 2015, all the activity we've seen. Every year we are seeing legislation proposing adding sexual orientation, transgender status to Title VII. Many states already do, many municipalities already do. I think it's just a matter of time before we see that added to Title VII. So employers should really start employing some best practices. Under federal law, are you required to cover sexual orientation and transgender status in your EEO policy? Well, the EEOC thinks you should, but you know, it's open to some debate. But is it a good practice because we know that you have to address it? Absolutely. You want to make sure all employees, because it's a sensitive issue, you want to make sure all employees understand that you don't tolerate any discrimination. You want to make sure your managers and supervisors understand, because frankly, the frontline managers are usually the ones that are dealing with some of these sensitive issues. And I think maybe a common theme that we can come away with today is communication with your employee. If you have a transitioning employee, communicate about their needs, just like you would communicate with an employee with a disability or an employee who is pregnant. And of course, if you get a complaint, promptly investigate it. And just as we're going to wrap up, here's another celebration. The EEOC is 50 this year, and the current chair has blogged, so another use of social media, about kind of where they stand and what they think is important. And the chair, at least, has said the EEOC is committed to mediation and conciliation. I don't know if we're all seeing that on the more local level, but here are some things on the horizon that you should be looking for. These have been top priorities, the ones we've talked about today, over the last couple years. But the EEOC is going to move on, and they're going to focus on other things. We already know that from what the guidance they're putting out, the listening sessions that they're holding. So what should you be looking for? Sexual harassment. The EEOC has recommitted to that. Religious accommodations. We have a likely Supreme Court decision coming down on a religious garb case by the end of the term. Terms of settlement agreements. We already know that the EEOC has filed a couple lawsuits related to that. They weren't successful, but the EEOC doesn't give up easily. Scope of conciliation, another recent Supreme Court case that was kind of clear as mud, so I think we'll see some more activity on that. And then the EEOC has indicated they're very interested in equal pay issues, and we may see some changes to EO1 forms to relate to that. So as we're closing up here, let me say this, that we promised to end at 1:15. And if you have additional questions here in Cleveland, we're happy to spend some time talking with you. For those of you viewing on our webcast, you can still email your questions and we'll get back to you. Our team continues to follow the latest developments regarding labor and employment issues. One of the ways we communicate this information is our online community, The Business Advocate. I hope you're all checking that frequently. The URL is on the front of your handout. Tune into the Business Advocate for follow-up on any questions you have today and for a replay of today's broadcast. We look forward to hearing your thoughts and perspectives from the subject we discussed today. You'll receive a survey requesting feedback on the business hour today, and we encourage you to respond. And thank you for joining us.